Good evening. Welcome to the National Centennial House, the home of the law offices of John Lewis Wilson. Speaking to you this evening, in addition to myself, John Wilson, is Ed Martin, one of our staff attorneys. We're located at 111 Ontario Street in Lockport, New York. And you can also visit us on the web at www.johnwilsonlaw.com. This evening, I want to take a few minutes to have Ed discuss the high points of the Divorce Reform Act of 2010. This went into effect in October of last year, and there's some salient changes. Ed, can you begin just by telling us what the more important changes that came into the law last October were?
Sure, John. Among the many changes, some of the more important ones were the new irretrievable breakdown of the marriage ground, which was the first addition in many years to the grounds available for participants in a matrimonial action. There was also an overhaul with regard to financial issues, such as temporary spousal maintenance. There were some changes with regard to the award of attorney and expert fees in matrimonial actions. Those were some of the bigger changes.
Looking first, or talking first, if you will, about that new ground, I know that the law as to grounds for a divorce action hadn't changed, I think, since 1974. So this was significant to bring in, I guess, what's been dubbed a no-fault ground for divorce.
Well, New York, as progressive as the state is, hasn't been seen as progressive with regard to matrimonial fault. While most other states, if not all other states, have allowed new provisions in the law for no-fault type divorces, New York finally got around to it last year. And irretrievable breakdown of the marriage is a no-fault, if you will, ground for divorce. And by that, it means that you don't have to allege that the other party to the action, your spouse, has committed wrongdoing, such as cruel and inhuman treatment, adultery, abandonment, or things like that. It's enough now, under this new ground, to simply say that the divorce is irretrievably broken. It's been that way for a period of at least 6 months. I'm seeking a divorce.
Nothing more. No specific instances of why the marriage has reached that point of irretrievable breakdown?
No, which is why it's commonly referred to as the no-fault ground now. You don't need to allege fault, and there is no defense to this allegation because you're simply saying the marriage is broken down. I want to end the marriage on that basis. The only caveat is that the court will not grant a divorce until other issues relevant to the divorce, such as custody, visitation, if those are applicable, financial issues such as equitable distribution of property, allocation of marital debt, child support, spousal maintenance, things like that, until those issues have been resolved.
Now, you mentioned spousal maintenance. Is there a change in connection with this same new law regarding computation of temporary maintenance? That is, the amount of maintenance that a spouse might be entitled to during the pendency of the action.
Well, with due respect to the new ground, which is big news in itself, I think that most people who are getting into divorce actions since October of last year are finding that the temporary spousal maintenance provisions are perhaps the biggest change in the law. What they've done is they've created a formulaic approach to the payment of spousal maintenance, in some ways similar to what the courts have been doing for years with regard to child support. They're now looking at what the moneyed spouse earns compared to the non-moneyed spouse, and with the exception of certain factors that the court considers, they're awarding temporary spousal maintenance based on the difference in income between the two spouses.
Without getting into the technical method of computing temporary maintenance. Can you give us a rough rule of thumb of when the less moneyed spouse might be entitled to receive an award of temporary maintenance?
Sure. If the more moneyed spouse is earning perhaps 1/3 or more than the less moneyed spouse, the less moneyed spouse upon application is probably looking at getting some award of spousal maintenance. Again, general rule of thumb, there are a lot of different factors that the court takes into consideration. But yeah, 1/3 would probably be a general rule of thumb to work from.
How about a temporary award of attorney's fees? As we know, sometimes the less moneyed spouse simply is not making enough money to even be able to afford the assistance of counsel, recognizing that the legal aid is oftentimes too busy or underfunded and is unable to provide counsel free of charge. What changes occurred in that area regarding temporary award of counsel fees?
Well, there has been a change there. The biggest thing is that the new law, the revised law, has created a rebuttable presumption. Being able to seek and obtain attorney's fees and expert fees and so forth is nothing new. That was the law before and that is the law now. But what the Divorce Reform Act of 2010 has done is created a rebuttable presumption that the less moneyed spouse should receive attorney fees from the more moneyed spouse. And now, rather than just putting the issue before the court and having the court decide, there's a rebuttable presumption created that attorney's fees and or expert fees should be awarded, and it becomes the burden of the moneyed spouse to rebut that presumption and show why it shouldn't be awarded or why the award should not be as much as is being sought.
So the less moneyed spouse gets a helping hand or a head start, so to speak.
I think it'd be a fair conclusion from the overall tenor of what the law has been interpreted over the past year, yes.
Ed, thank you for covering some of the more important points in the Reform Act of last year. Thank all of you for listening. Again, if you'd like more information, feel free to contact us. Local telephone number at the Ontario Street office is 716-434-2010. Our Lyndonville office at 9 South Main Street can be reached at area code 585. The number is 765-9481. And again, if you want to visit us online, please do www.johnwilsonlaw.com. And remember, we spell John, J-O-N.